Greetings, everybody. This is Professor Hussain here with week two of AVM ASC 2320 Aviation Law and Regulation class. Welcome back. This is today we're going to be covering briefly Chapter 5 with reference to organization of businesses. Uh, and then we'll talk about forms of businesses as well. The forms of in which aviation is organized as one of the factors can be used to control potential consequences of legal risk inherent in doing business. The primary forms of business are obviously we know sole proprietorship, general partnership, limited limited liability company (LLC), and these are the different types of forms of businesses here. In sole proprietorship, the business is owned by a single individual who is personally responsible for debt of business under principle of vicarious liability discussed in preceding chapters for torts committed by employees of business while acting within the scope of them. So in essence, this what it means is, in a nutshell, is that if you do have a sole proprietorship, you will be held responsible for anything and everything in that company when it comes to liability. So you want to make sure, even acts or torts committed by employees will be your responsibility. So it's best to make sure that you know exactly what you will be getting into when if you do go this route. So limited liability, the same personal exposure liability applies to each partners in general partnership. Even limited partnership are required to have at least one general partner whose personal assets are at risk for business liability. Although limited partners enjoy protection from personal liability similar to affordable shareholders of corporations. So in general partnership, obviously, in this also, if there's two partners, you will be held responsible for it as well. And most importantly, at least, like it says, at least one general partner whose personal assets are at risk for business liability. So in no way can you put yourself in a position where you will be held liable. So that's another way to make sure that you are keeping those risks minimal. Until fairly recently, corporation was the only form of business in which no owner of business took on added risk of vicarious personal liability for torts committed by employees of business for the debt of business. So that's one way of looking at it. States have adopted laws permitting business to be organized as a limited liability company. Now, you will see this LLC in front of the corporation and in front of the company's names, indicating that, both of these owners enjoy same protection against personal liability as shareholders of a corporation. Although relatively new to US, LLC is hardly a bold experiment, having existed in Europe and South America. Tax consideration for particular enterprise drive the choice between corporation, LLC, and limited liability partnership as more appropriate form of business. A properly formed LLC or LLP, as well as small business corporation that elects to be taxed as a partnership under subchapter S of Internal Revenue Code, called S corporation, can possess both limited liability of corporation, and pass through tax treatment of partnership. However, not even corporations or LLC or LLP will protect you from personal liability for consequences of your own negligence. The article of incorporations are to a corporation as constitution is to a nation. They are most basic documents expressing what has been created. Although most states allow you to create corporations by completing and filling a very simple form and paying a small filing fee, you will probably find the cost of having your attorney draft original customized articles of incorporation is well worth a modest additional cost. When the state accepts your article of incorporation, issues a certificate of incorporation, the legal equivalent of birth in the family occurs. Adequate capitalization. There is no hard or fast rule on how much capitalization, money or assets, is required for a corporation. But the more you strive to keep it an empty shell, having no assets exposed to potential claimants, the more likely it is the judge or jury will pierce that corporate veil to reach your personal assets. Your attorney and accountant can help you decide what assets should be held in corporation name, given the nature and corporation of circumstances of your particular business. So, and in essence, all it means is it is best left to the accountant and business lawyers to really decide how you're going to incorporate your business while at the same time protecting your assets from potential liabilities. Coming to multiple shareholders, while a single shareholder may legally own a corporation, this is another factor a judge or jury should consider as one brushstroke in the big picture of whether it was really operated as a corporation. Having more than one shareholder makes the business look more like a real corporation to most people. How to sign a corporation? Although corporations can legally enter a contract, it takes a human person acting on behalf of a corporation to sign the contract and write the check. If you are that person, you want to ensure that it's apparent to the world that you're signing the contract or writing the check only on behalf of the corporation as its agent and not personally. There's only one proper format in which to sign anything if you're signing it for corporation, not individually. This signature block must include three elements: the corporation's full legal name, your signature, and your corporate title. So you need to have all three of them there to make sure that you are signing as a signing for the corporation. Full name that needs to be repeated in the signature block. Proper form of corporation signature, keeping personal and corporate assets separate. If you want the world to recognize the corporation as a separate person, then you must do so too. Don't put the person's money in your pocket. Care must be taken. Making documentation and making and documenting corporate decisions. Part of this process of acting like a corporation is making corporate decisions at the appropriate level and keeping the proper paper trail that proves that you have done so. Corporate decisions may be made at several levels: shareholders, board of directors, executive committee of board of directors, officers, and employees. The powers, duties, responsibility, and procedures for corporate decision making should be spelled out as clearly as possible in the article of incorporation or bylaws. That's another important thing is to remember. Remember the bylaws. Normal corporate operation, the only decision the shareholder has the right to make is to elect a board of directors to govern the corporation. Also remember, regardless of forms of your business, whether corporation, limited liability company, partnership, sole proprietorship, or other forms, the business has a certain legal obligation towards each of its employees. This includes the duty to provide workers' compensation insurance, unemployment compensation insurance, to pay agreed wages and withhold payroll taxes, and to provide a safe place to work. Workman compensation insurance in popular mythology of social welfare state statute makes it mandatory for employees to provide workers' compensation insurance coverage to compensate their employees on the job injuries are celebrated as a great victory for making classes or exploitative employees employers. In reality, however, workers' compensation is so far more advantageous to employer than to the employee. IRS, like dynamite, is stronger than you are and no friends. Revenue collecting authorities have extraordinary powers not only enjoyed by administrative and law enforcement agencies. So it's best to make sure that, in a nutshell, what it means is making sure that you are paying taxes, uh, which are due on time, and processing all the records according to the laws. And the best way to do it with this again is have an attorney, have an accountant, take care of all these things. An FBO wishing to avoid expensive paperwork inherent in insuring and withholding payroll taxes for flight instructors elects to treat them as independent contractors. One day IRS agent shows up at the business, inquires into the whereabouts of one of those instructors, mentioning the instructor didn't file federal income tax returns during the time he was instructing for business. He left here a couple of years ago and haven't seen him since, although I did hear of rumor that he was killed in a crash of drug smuggling. Uh, so best is obviously have records of your boy. He was an independent contractor. FBO manager explains we even require our flight instructors to sign a contract showing that they are. Here is a copy of once he signed. Unfriendly agent is persistent interrogation, gaining the manager's admission that flight instructor did give and draw instruction in FBO's classroom. Had the use of desk of FBO, used FBO's FAA-approved syllabus to teach. The instruction was given on aircraft provided by FBO according to schedule determined by FBO's dispatcher. Instructors had to give instruction himself. He couldn't send a buddy and substitute for him. He had something else he had been doing. So, in essence, what it means is he was utilizing FBO's facilities for his instructions. So, in essence, he was working for them. That's what it means. Revenue agent may decide that under these facts, the FBO had the right to control and direct the flight instructor's work. If so diligent taxpayers were really an employee, the FBO had failed to withhold payroll taxes for his employee, must not pay these taxes to IRS with interest and penalties. If business does not cooperate in promptly taking care of the obligation, agent may freeze the business bank's account and seize its assets until matter is resolved. And also remember, if the business doesn't have the funds to pay this tax liability, government will sell the business assets to satisfy debt. The sale of assets still doesn't satisfy entire liability. Then, if business is sole proprietorship or partnership, the proprietor or partners are personally liable for balance due to the IRS. If the business is a corporation, its directors can be held personally liable for unpaid taxes, tax liabilities of corporation. The business and its owner, or in case of corporation, directors can't even escape that tax liability by filing bankruptcy. Tax liability by statutes not dischargeable in bankruptcy. So remember, this is serious matter. Liens of defense and risk management. If you decide with advice of your lawyer and accountant to form your business or corporation, LLC, LLP, to protect you from potential personal vicarious liabilities for torts committed by other workers, this should not constitute the entire risk management plan for the business. The same is true of business risk management strategies. While organizing business as a corporation, LLC, or LLP, is an important element in the risk management plan you develop for your business. It should not be the only one. So in essence, and what in a nutshell, what it means is if you are forming a government, forming an FBO or a business, it's best left to the accountant and advice from the lawyer uh, that will protect your interests in not just the short term but long terms as well. This is it for chapter 5, and I shall continue with chapter 6 in the next lecture. Thank you. Have a great day.